Good afternoon. How are you? It is a pleasure today to welcome Professor Geoff Gordon on behalf of Facultad de Ciencias Jurídicas, Javeriana Law School, the Department of Economic Law, and the Semillero. Professor Gordon, it's certainly a privilege to host you and share with our students your research, interests, and writings. I want to begin by using a Spanish word which translated into English is to teach, but in Spanish, perhaps it's because of, perhaps it has a Latin origin. To teach, enseñar, is also to show. So one of the ideas of this talk, of this chat today, is to show the students at Javeriana what a good piece of research is, what a good conduct of research is about. So it's a privilege. I know Professor Gordon research activities, so it's really an honor. One of the things that I want my students to do when conducting research is something that, in fact, Professor Gordon has achieved during his career. I find that even though Professor Gordon, in a few minutes, I will read his biography, which is very impressive, is that you are a truly philosopher of international law, in my opinion. There is a thought attributed to Schiller and Goethe as well. They say something like the hardest thing to see is what is in front of your eyes. And I think that Professor Gordon achieves that. He sees the big picture. He sees things that no one else does. He asks questions that nobody else asks. And at the same time, he enlightens us. So his contributions are very important. I just want to illustrate the audience about who Professor Gordon is. He holds a BA in literature from Hamilton College. He holds a PhD from Vrije Universiteit. Hopefully I'm pronouncing it correctly, Amsterdam, and a JD from Columbia Law School. His PhD dissertation dealt with cosmopolitanism in international law. Currently, he's a professor at the Faculty of Law of the University of Amsterdam, and he's a senior researcher at the TMC Asser Institute Center for International and European Law. He's also the current editor of the International Legal Theory section of the Leiden Journal of International Law. So your CV speaks for itself, your work. I have to say, sorry about this, Professor, that you are one of the finest writers I have read during my academic career at Javeriana. So it's an honor. The floor is yours, and then we can start the dialogue. Thank you very much. Finally, I want to introduce everybody. Antonia, who is one of the brightest students at the law school. Thank you very much, Antonia. And she will be coordinating all the questions asked by students. Thank you very much.
Thank you very much for that very warm introduction. It is an absolute privilege to be here. I'm familiar with Professor Tellez's work, and we share a lot of common interests, and I've really benefited from it. And to be able to speak to this audience is wonderful. Thank you, Andres. Thank you also, Antonia. It is an honor to be here.
No, thank you very much. Let me share what we are going to do today. In terms of the outline, how we are going to develop this. Professor Gordon basically is going to explain his research interest, the conduct of his research. Then we will have a dialogue between 20 and 25 minutes where we'll be discussing some aspects that are key in terms of academia, black letter law versus critical thinking, what I call, or in general, in philosophy and in law is called phenomenology. We will discuss whether this is true or not. and some notions that Professor Gordon has studied during his research, value, deferral, network. I told my students that method is very important. In fact, one of the articles that I want to show, the word method is mentioned at least 4 times, which is very, very important. The role of international law and international lawyers today. Then we will have between 10 and 15 minutes where students can ask questions via the YouTube chat. Antonia will be channeling those questions. And at the end, as I told the audience, to teach, enseñar, to show them what a good piece looks like. So thank you very much once again, Professor. You have the floor. Thank you very much.
Wonderful, thanks. Okay, first I will start with an apology. It's late here, it's 8 o'clock, so the light is going to start changing on me soon, and I hope that won't cause any problems with the camera. What I'll do with these opening minutes, maybe a little more than 10, hopefully a little less, is I'll try to make 5 quick moves that anticipate the rest of the discussion to follow, and hopefully offer a little context to build some questions with. I really encourage you to send any questions through Antonia. I find that can be the most dynamic part of the conversation. It's also a reason for me to keep these minutes short. So without further ado, the 5 moves I will make, the 5 things I'll try to do in these few minutes, I'm going to start at the end and talk about some of the objectives that I've been working towards. From there, I will flip back to the beginning and start with one of the fundamental insights that's sort of been foundational to everything I've tried to do since the PhD. From there, I will then start to get a little more specific. I will go from that foundational insight and touch on what method means in this context. From there, sort of point to the piece that Andres has zeroed in on for this talk, the Contradiction in the Court piece. Talk a little bit about that in the context of this foundational element method, and use that then to pivot for the next move, the last one, to where I've gone since then. And as part of that, I'll talk about some of my frustrations with that piece, some of my own feeling of inadequacy in what I was able to do there, and how I've tried to fill that with further work. And once again, I do want to say a very sincere thanks for having me. This is a real privilege. Okay, so to start at the end, I would say the objective for me is in a series of questions. How do we know what we know? How do we know what we do? And how do we do what we do on that basis? I have been a practicing lawyer before I was an academic. And so many colleagues would define differently what their objectives are with the study of law. And that's excellent. I mean, there's just an infinite number of good purposes to which you can take a life of learning and apply it in the context of law. For me, the privilege of being at university and having this room to study is to ask these broad questions. How do we know what we know? How do we do what we do? And how do we know what we do? And in a very confusing time, such as the one that we're living in, to take a concrete practice like law and ask these very basic questions to me is very important. To already sort of allude to the piece that we'll be talking about, contradictions are very important for me in this. We take so many things for granted in our professional lives, in our day-to-day lives, in the practice of the law, in our assumption of what a legal argument is and what a judgment should represent. When you look closely, you find a lot of inconsistencies. And these inconsistencies can be very frustrating. Many colleagues, those who are orient their work around more focused questions, spend their lives trying to smooth out the inconsistencies. But it seems like for as many inconsistencies as you smooth out, others appear elsewhere. It's sort of, you wind up chasing your tail a little bit. This can be very frustrating, but it's also an invitation to look more closely. That's both the sort of joy and the objective, and hopefully it has a normative element to it in doing what we do with further study. Okay, so that's what I've been trying to work towards. That's where I'm not there yet. That's the end, and I announce it prematurely at the beginning. Where's the starting point for this? There are a lot of starting points. I mean, the one that I'd like to put on the table, because I think it sets the framework for a lot of what follows, is the indeterminacy thesis. I don't know if to what degree that is going to be a very common formula already. Not so long ago, it was all the rage in the areas of academic law that I was in. The indeterminacy thesis is a fairly simple point, and it comes from 20th century linguistics, from what's known as structuralist theory. And it's the idea that signs, words, rules don't announce themselves. They don't contain their meaning in themselves. They're not transcendent truths. They are given meanings in a variety of ways through a variety of things, people, material contexts. This is problematic in a rules-based practice like international law. It's a basic argument that the rules in themselves are not sufficient to tell us what they mean. So there's no amount of study that's going to tell us the one true meaning of the rule. That meaning is always the product of a constellation of factors around it. Now, I'm not ever sure, and it's especially difficult in a Zoom context to know to what degree this sounds obvious or sounds very opaque and unclear. I will say this, among the groups of people that really work with the indeterminacy thesis, there are people who are very theoretical or with interest in theory, such as myself, but also practicing lawyers, such as I once was. A practicing lawyer tends to know they don't get to choose their cases. You know, someone comes and says, this is what happened, and I want to bring a case to do this. One lawyer is hired to argue one side of the case. The other lawyer is hired to argue the other side of the case. They're both going to rely on the same rules. They're just going to say that the rules say a different thing. So it's at once a very practical thing. It's at once a very theoretical thing. In between, there's a lot of assumptions made about what rules mean, and the indeterminacy thesis unsettles that to a certain degree. That's just the starting point. And there's a second part to the starting point, because if the indeterminacy thesis were all there were, we'd have a bunch of rules with no solid meaning, right? Law, words generally would be arbitrary. Yeah. So the follow-up question, I think the obvious one is, well, what holds it all together? Rules may not have a transcendent meaning. Rules may not announce themselves. Lawyers may be hired every day to argue both sides of a rule. Nonetheless, legal practice produces consistent results all the time. What the indeterminacy thesis is doing is not saying that the world is arbitrary, pointing us towards nihilism. But what it is doing is saying that it's not the rules themselves that are producing the consistency. There's other things that allow the practice of law in its many forms and instantiations to produce consistent results. Something stabilizes the meaning of these rules, something not internal to the rule, but around the rule. Yeah. Okay, and so that then, moving very quickly, make that third move that I mentioned in advance. So I'm interested in what is it that stabilizes the practice of law, the meaning of the rules that we use. This, to me, opens up a whole host of questions around method. How do we understand what it is that holds together the practice of law? The indeterminacy thesis for someone such as me has said, we can't only have recourse to the words that the rules are made with. Certainly, for the same reason that the indeterminacy thesis is not an invitation to nihilism, those words are a critical component of understanding the context in which law has consistency, but they aren't the whole of it. And that raises questions of method. Where do we look? Depending on where we look, what's the right way to understand what we're seeing? The law is a particularly interesting place to raise questions of research method. Let me back up one moment. In case I'm already going a little too quickly, research method, an anthropologist will bring one set of methods to understand their field of study. A literature student will bring another set of methods to understand their field of study. A biologist will bring another set of methods. Within the social sciences alone, there are many different methods. Law is a very interesting place to raise questions of method because law is both a formal exercise, one that operates around formalisms, around a code. It is also, if you take seriously some of the concerns I've already mentioned, an empirical exercise, one that needs to be understood in its material realities. Law is, this may be a controversial statement, I don't know. Law is an ideological exercise insofar as it is so closely joined with the political operation. Law is a historical instrument. Law, in many systems, brings its history into its present operation. So it's a meeting point of many things that on their own have entire sophisticated methodological apparatuses set up around them. So it's a really fascinating place to raise these questions of method, and a very important place. Okay, so contradiction in the court is a long effort to work out some of these methodological concerns around a very curious, very sharply defined problem for international law. I don't know if it's still the case, but I know that in each of my places of training in North America, in Europe, I would regularly continue to hear international law. Is that really law? And the International Court of Justice, as a famously hamstrung institution, is a very curious example of a highest court. Contradiction and the Court, piece that sort of working as a centerpiece today, was an effort to use this very sharply focused problem to bring a variety of methodological questions to understand the operation of the International Court of Justice, and through it make some broader observations about the system or systems of international law. Now, I will say that the piece itself was, I did not feel that I was able to achieve my ambitions with the piece, in part because I loaded so many ambitions onto it. So in a moment, I will make the last move of these opening minutes to talk about some more narrow examinations that I've tried to do. But contradiction in the court starts with an insight that I borrow from a historian, from Ellen Meekson's Wood, with an understanding of the role of economic coercion in capitalist systems. She makes an observation of the way that direct coercion under feudal systems gets replaced with an indirect form of coercion, economic coercion, which itself is backed by force in capitalist societies. To understand what work that is doing, then, I tried to bring, on the basis of that historical insight, I tried to bring material analysis through what is in the piece as actor network theory, together with social analysis from the sociologist Pierre Bourdieu. I'm still not totally convinced of the way I brought them together. And what I've tried to do since is sort of zero in on different pieces of what I was bringing together there. And so here I'll move to this last part, and I'm probably already over the 10 minutes. So I'll try to do this very quickly, and we'll have time for dialogue and hopefully some questions. So one area that I've broken out from contradiction in the court is to take a really close look at some of the materialities of law. And so if part of contradiction in the court was looking at the way networks and material objects hold things together around the International Court of Justice, in contradiction in the court, the objects were things like oil, and I've gone much farther with a fuller list of material studies, most of them technological. So I've spent a lot of time looking at the way that new technologies and infrastructures interact with law, the way that law is conditioned by the infrastructures that support it, the way the infrastructures that support law are conditioned by the law that they are supported by. I have a piece mapping values in AI governance, trying to understand in this complicated space of new technologies how normative direction takes shape. Much of this is through the way that law is present in a conditioning role, but it's hardly a direct command. The law is getting conditioned by these AI technologies as the AI technologies are getting conditioned by legal practice. So there's a symbiotic relationship that doesn't offer an obvious endpoint. Okay, so that's an example of some of the material studies. Some of the social studies are in a book that I recently co-edited with Isabel Feichner, Constitutions of Value, looking at the way that value itself is supported by legal practice, the way legal practice, again, often very circular, the way legal practice is conditioned by value. These studies start with an observation coming out of academic economics, in which there's been a realization lately that the theory of value underpinning the study of the economy has been neglected for too long. And what used to be taken for granted as an adequate theory of value no longer explains a lot of economic phenomena, which it is kind of startling from outside of the economic world to think that, you know, the understanding of the economic world is now divorced from its own description of where value comes from. And so we tried to take that and look at the ways that law is implicated in the production of value, the way that law is conditioned by the production of value. And this is done against a frankly normative understanding that the world's in a bad place. That there's just, there's a lot of problems getting produced by dysfunctional value sets. And so part of that was, it was a clearly sort of normative ambition to try to chart a path towards a clearer understanding of value production, to be able to support more sustainable values. And finally, to wrap, there is a meeting point of these two elements, the material and the social. And I'll sort of push unashamedly into, my battery's getting low, so you're going to see me reach behind me for a second, into a somewhat specific language. But the meeting point is in information. So I'm now very interested in the idea of law as a communication system. Law as a communication system that is built with communications technologies that include people, and which has some very funky effects once you start to look at law this way. I've begun to see many places of institutional practice in international law as management exercises, lawyers as managers, as opposed to whatever self-definition we lawyers might otherwise give ourselves. Okay, I think I'm well over my 10 minutes, so why don't I stop there? And I hope that along the way, I've already planted some seeds that you can develop into questions as Andres and I now take up a bit of dialogue.
Great, Geoff, thank you very much. Let me share the screen so students can have sort of a guide of what we are going to discuss in around 20-25 minutes. This is basically like an outline of the talking points Geoff and I discussed. But before that, before the dialogue, I just want to summarize some very interesting points presented by Geoff in terms of his research. You began by talking about the indeterminacy thesis, which I find very, very important. I will try to explain very briefly in my own words what I understand and the importance, and then go on to like the three tenets of your recent pieces, no? The material, the social information. So let's begin with this. Black letter law and critical thinking. You say, we see some results in the real world. Yeah. But on the other hand, we have the law itself, the meaning of the law, the problem of interpretation, which in a general sense, I would say is an hermeneutical problem, which is what we have to deal every day as lawyers. That happens, of course, in public international law in general, interpretation of treaties, interpretation of rulings. In international trade law, it's a common issue, how you interpret an expression, etc., etc. But at the same time, we are seeing that rulings are issued, conflicts are adjudicated. Okay, why I find Geoff pieces and thought process so relevant and important. There's a distinction in common law between what is settled. This is something that is not apparently discussed or should be discussed anymore. I don't know, a notion, what a particular institution is, and critical thinking, what is underlying, what is the problem is. Of course, you are here, you are in the critical thinking part of the equation. Is it true? My question would be this, Geoff. Can we talk about black letter law when in fact, yes, you may have some institutions where debate may not be that common, but perhaps by seeing reality, by seeing the problems of society, you talk about constitutions of value, injustice, materiality, information, perhaps our understanding of the existing law is not right, is not correct, and we have to go a little bit deeper.
I think both of these, I think that's a very accurate closing point on the question. And both of these things remain crucial to a living law. A close study of the black letter law is a first step to being able to operate with and within the law. And the law, to the extent that it is a thing, that it is a distinct system, it is a code. It is a specialized code that requires its training to be able to operate with it with skill. However, to know the law only through its... Okay, so now at the risk of being confusing, black letter law is a little bit misleading in the sense that those trained in it, unreflexively, there is a sense that the black letter is sufficient to understand the law in its entirety. And that is not adequate. To be trained in the black letter is to understand the expectations of the operation of the law and to understand how to mobilize the rules that you're working with. But again, the black letter lawyer will be prepared to mobilize a rule in either of two different directions. So the training in the black letter is necessary to be able to do that work as a lawyer, but it's not adequate to understand the system in its normativity, the system in its distributive capacities, the way that it affects people on the other end of it, the way that the practice of black letter law produces winners or losers. So to understand the code as a black letter lawyer is to understand a mode of practice, but it's not to have some special access to a singular truth or meaning that others don't have. So then, to understand what it is that's allowing this practice with the code to produce this set of winners on a regular basis and this set of losers on a regular basis requires something more than the black letter, than a study of the black letter as black letter itself.
Thank you. Of course, black letter, as I told my students, is a notion typical of the common law system. Perhaps in the civil law system, we have something similar in terms of, okay, we know what the institution is. Of course, there is jurisprudence, there are theories about that. but there is, which is what you do, in my opinion, no effort to go a little bit deeper. You mentioned a few minutes ago this research method involving an ideological exercise, a historical exercise. Let me give you an example, and perhaps we can illustrate the students about this, which is hermeneutic in essence. And of course, this is nothing new, but I think what you have done help us understand this a little bit better. What people in the US or in the International Court of Justice or in the Netherlands or in the University of Amsterdam, academics, fine academics like you, understand in terms of the meaning of a concept of international law, whether it's trade law, public international law, UN Charter, etc., etc. How is it, or how can we approach the problem that what people in Europe, in the US, see as the meaning of a particular and very important notion? For example, in Colombia, with all our problems, with our context, or in Latin America, is understood differently. In your article about the court, you talk about how the structure is designed, yes, to produce some results, but how the International Court of Justice, in the end, ends up promoting economic coercion. Okay, let's, for example, take the meaning of coercion. Coercion. What is the meaning of coercion for a person at the Department of the Treasury in the US when seeking to sanction, I don't know, a country like Venezuela or whatever? What is the meaning of coercion and sanction for the Venezuela's government? Yeah, we can resort, and I know all of you know, the students, and of course you do, we can resort to the dictionary, but that's not enough. That's not enough. How can we reconcile? I think that is a hermeneutic problem, very, very difficult. Now, perhaps, as we discussed, Geoff, perhaps the conclusion is that there is no conclusion, that that we are not able, that we have a limitation in terms of understanding everything. Perhaps we cannot understand, and perhaps there is an imposing view about the meaning of a particular notion. I don't know what your take, your viewpoint about that is.
Wow. I mean, it's a rich and powerful and important question, and it touches on so many things. It touches on issues that are bound up with law at any scale, but are particularly acute at the international level. The hermeneutical problems are especially difficult in this very diverse space of different interpretive communities. I don't think that I can answer the question, but I can suggest where some of the difficulties of the question have pushed me. I mean, this is one of the difficulties of addressing this question have pushed me to an interest in materialities. So the person working in the department, in the State Department of the United States, may have a different definition of coercion with respect to the United States actions vis-a-vis Venezuela than someone working in an office in Iran or China or else, or the Netherlands. And there you can get into a variety of questions about what supports the legitimate understanding of coercion. I'm at this point not so terribly exercised about questions of legitimacy. I'm more interested in questions of materiality when we get into these diverse spaces. Are people in Venezuela hungry? Are they hungry because for reasons that have to do with social systems? Is there a stoppage of resource flow around Venezuela that has to do with the combination of people, things, and code in which Venezuela is implicated. By which I mean, global value systems, um, resource movements. International law does not determine resource flows, but international law is a tool along with information and communications technologies, along with ports and boats and airplanes, and looking at the conjunction of the way the individual working in the State Department in the United States operates together with a person working in the back office of a bank in New York City, operates together with someone directing long-haul boat traffic in Greece, operating in conjunction with the person who is maintaining undersea cables for the flow of information off the coast of Africa. This sort of network and web of things has real effects. I don't know if I both exploded the context in a way that may be unhelpful, and I'm also cheating by pointing to a variety of things. But as with Contradiction and the Court, where the things that require looking at become very many and very hard to follow, what remains simple is a question of material effects and material distributions. And that holds together for me when an effort to define coercion becomes a really tangled hermeneutical problem.
Excellent, Geoff. One final question. I asked my students to read your article, and in the next few weeks, we're gonna discuss some of your findings and some of your thoughts. I began this presentation by quoting a German thinker that the most difficult thing to see is what is in front of us. And philosophically, I've studied the concept or the notion of distancing oneself. It's like when one have a piece of paper, one has to like take a distance to see better what the contents of the piece of paper are. What would you recommend us in general as academics, as lawyers, which is something that you excel at, in order to, on the one hand, study the law, which is part of what we have to do, but of correctly perceiving reality in terms of what is happening, but also in terms of evaluating and assessing. We talk about materiality, you talk about an empirical exercise, an historical exercise, an ideological exercise. Whether that piece of law, whether it's international or domestic, is playing in the context of reality. So yes, we have to see reality, which is what you do very well. You see what many people do not, but how we can interpret reality and the interaction with the law. What would you recommend? What is what you do? You talk about method, and in a few minutes I will show your article, and I will show some sections that that evidence that how can we better observe reality in the context of the interaction with the law.
Oh boy, that is tough. That is tough. And I will say this, that is a wonderful quote. And when you brought it up at the very beginning, I don't know if you noticed, I was scribbling it down. I really did want to return to it. So that is wonderful. And I'm glad to have the chance, although I don't think I can do it in the form of a recommendation. One thing I will suggest specific to law, and this is borrowed from Duncan Kennedy, who I believe borrows it from others. Especially as a former practicing lawyer, I find that the most interesting work that the law does is rarely the stuff that's put at the center stage. The sensational judgment, the moment of decision, is often to me anticlimactic. More interesting, having talked about this idea of the stabilizing role of law, having just talked about the way that distribution flows of resources happen, it's hard to pinpoint the flow of resources into Venezuela with a single decision. And I think you could say that about many different contexts, whether national or international. More interesting to me is the way that the law is implicated in a web around where that center happens. I think the analogy that no, I can't remember exactly the illustration that Duncan Kennedy used that I'm trying to recall. But the idea is that if there's a fight at the center, those that are in that contest are already there on the basis of a web of connections that allowed them to get there. That what we see at that moment, at that shining moment of judgment and decision, is the product of many things that allowed some arguments to work and some not to, that allowed some lawyers to get to that point and others not to, that allowed some people to come into that court and did not allow others to, that makes some things visible, whether visible in the sense of worth fighting for, visible in the sense of useful to fight with, and makes other things less visible, that leaves some concerns outside of that moment of decision and allows some concerns in. So my one thing I hesitate to call it a recommendation is consider not only the sort of spectacular moment that we're often trained to focus on through legal teaching. You know, we study the judgments, we study the decisions, we study the rule. And think about the way that law is active in the background at all the points prior to the moment of decision, conditioning the arguments that are made understandable and possible there. The other thing I would suggest is back to where I started. And for any given thing that seems to make obvious sense, if you push yourself a little bit, there's often the moment at which you realize it contradicts something else that seems to make sense in the sort of way that both of these things can't be true, right? So the professional working in the State Department, whether it's the United States or elsewhere, who says, well, of course, this is not coercion. This is simply statecraft. Then if they work a little bit hard at it, they can find themselves in other contexts where they think, well, this is coercion and not just statecraft. And the two conclusions conflict. And that then invites some probing. What, you know, why did my common sense lead me to two opposite conclusions about a similar practice? And that to me is also the responsibility. When I get into these highfalutin, very abstract things that connect up undersea cables with lawyers in an office far away, ultimately it's about the student of law who becomes the practitioner of law, thinking about their responsibility in an interconnected world.
Absolutely, absolutely. Just to sum up, as you know, my students are undergraduate students. I told you, law in Colombia is an undergraduate program, and one of the things that we have to be aware of is, as teachers, as professors, is to instill critical thinking. In the end, Geoff, in the end, we are dealing with two sets of relationships, in my opinion. Well, of course, the relationships between subjects, individuals, whether legal or juridical persons, physical persons, and the interaction between us and objects, materials, things. I think that two key words in your presentation and underlying your pieces. You began by talking about indeterminacy, but you talk about the importance of contradiction. So I think that as to critical thinking, that perhaps in the US and in the Netherlands, you have already achieved that level. I guess in Colombia, perhaps we're in the middle of that process. We have to take those two keywords into consideration. On the one hand, that perhaps not everything is clear. One has to dare to ask about what for everyone seems obvious, not everything. Well, one would tend to think everything is obvious. No, not everything is obvious. So when you take the law, international law, okay, I'm reading this, but one moment, what is the meaning What is the real meaning of this? Is this that obvious? Perhaps not. And at the same time, contradiction. Contradiction is key, whether in the context of an undergraduate program, whether in a PhD program, or whether when we teach or practice law. Contradiction is fundamental. Of course, it's not me, the one who says that. If there were no contradiction, well, life would be very boring. And Plato says in the laws that contradiction is the essence of the pedagogical activity, to contradict, to contradict. So yeah, on the one hand, relationships, networks between individuals and between individuals and objects in international law, of course, or domestic law as well. And on the other hand, contradiction. I guess we all, Geoff, at one point in our lives have been people who just repeat what others have said. So what we have to do, whether it's our parents, teachers, whoever, then we have to go one step ahead. No, okay, I know this, but then I want to ask about this. What is the meaning? One problem is that students in Colombia, perhaps in the US and in the Netherlands as well, they don't have too much time. I mean, they have to study, they have to try to understand. So the time to ask these underlying questions is not that much. They don't have time. They have to prepare for the test, etc., etc. But I think as a matter of professional and academic discipline is key. Is key. It's very important. So let's Antonia, perhaps you have some questions, and then I can show Geoff a piece, and perhaps Geoff wants to jump in and say something else. Antonia.
Yes, there are a bunch of questions, so I'll try to ask the most relevant ones. So the first one is as following. The general notion that people have of the UN is that it shows its power when a non-veto country is to be sanctioned, but that is toothless when a veto country is to be punished. In your conclusion, you account for the ICJ in how, by its performance, it projects an ethical ideal. Despite that, the International Criminal Court seems to only judge African and Latin American countries. Wouldn't you say that this is an unethical projection of the international organisms?
Yeah. Excellent question. And before I take on the question, I do want to just jump back to what Andres also said and really confirm, especially the difficulties posed by the pressurized time that we live in. That actually is a sort of leitmotif in sort of side work that I do through the law. I'm very interested in the way that we've come to produce time in the way that we do, and the effect that that has on our normative codes and legal systems. And just the way that students are conditioned is very much a part of the reproduction of legal systems, and the time pressures are a big part of that. Okay, now pivoting to this excellent question about the ICJ, the ICC. I am frankly, in very colloquial language, not a big fan of international criminal law. It's a system that I struggle to understand or get behind. The ICJ, I think I take it from the question that what I've written in the piece is relatively evident. I see the ICJ as projecting an ethical ideal that allows the partial coalescence around a system of economic coercion with the idea of some redemptive normative value. I am not, I think it's fairly clear in the way that I write that I am not convinced that we interrogate this enough. The ICC, I'm not sure I'm willing to discuss it in quite the same way, but it would be an extenuation of all of these things. It would be a bringing to righteousness of this ethical projection. And in a somewhat predictable way. It allows, so there's a lot of distraction around will the US, will the UK, will Israel be held accountable before the ICC? On one part of me wants to say, even if they were, and the other parts of me wants to say, this is an inimical use of resources and a system that projects. I want to not overdo it. There are very well-meaning and very intelligent people working in international criminal law and working to make the ICC a successful institution. But as an institutional project, I find it a problematic one. I'll leave it at that.
Okay, perfect. Thank you. The second question would be as following. Under the understanding that the law is not self-explanatory according to the theory of the terminology, if we aim at interpretation under hermeneutic criteria and critical thinking in order not to fall into the black letter law, what's the limit that we must establish so that there is a common understanding of what it wants to express, considering that interpretation can become a subjective exercise that, with the great diversity of readings, can end up skewing more?
Mm-hmm. Well, to the extent that the question is asking, what's the other thing that we can build? That's somewhere between a cheat and a hard question to answer. As I work with methodology on, having come there from spending some time with the indeterminacy thesis, this is part of a critical project to understand what that system that holds together is actually doing. It's not so much a proposal to develop an entirely new system from scratch. Interpretive science, so to speak, and interpretation comes in for study and doesn't become an endpoint in itself. Things hold together interpretive communities. I'm less interested in and I think the question understands this. I think this is part of the question. I'm not particularly interested in understanding the right mode of interpretation so much as I am in understanding what makes this interpretation work for these people and things. Ultimately, I'm not looking for so much what will hold together the new law, so much as what's holding together this law. And if we isolate, if we are able to find the elements that are working together to produce consistent results, what sort of change are we able to make as we manipulate these things that are now visible to us as having effects that weren't necessarily visible before? It's not quite the same as saying, where's the stopping point, or how do you create a new grounds for something? It's taking what exists and looking at the way it works to think about the way it can be worked with.
Okay, perfect. Thank you. And due to the time, I think that one last question is pertinent. So the third question would be, when you expound the actor network theory studied in practice in the Council d'Été in your paper, it seems to be possible due to the homogeneity of the people and things observed. Also, you supported the idea that the temporal dimension implicit in both methods was key element for studying these simile-antonym theories. In Colombia, the diversity of its people and customs is enormous. Would you say that studying with the A&T method is impossible or even dangerous in Colombia due to the fact of the impossibility of homogeneity and the absence of spatial dimension would be noxious for studies in Colombia using these methods?
Great question. So I shouldn't hold myself out as an A&T scholar, but one thing that I think A&T would offer in this context is A&T really works to suppress the idea of the social at the beginning. So one of the really strictures of A&T is the idea that so many other studies, without saying it, already know what it is they want to study. A&T says if you want to understand something otherwise known as the social, don't start out by assuming what the social is or what makes it up. Follow the connections. Yeah. And so what you can find it's not predetermined what you can find in a heterogeneous space. Now, if you're talking about a space in which you have a variety of wholly autonomous individuals or communities that have absolutely no interaction at all, then you don't have a lot of ability to trace a network. But if there is some sort of intercourse among these individuals, things, and groups, and here we're not just talking about people, we're talking about materialities. So if otherwise autonomous things pass through the same doorway, well, they are similarly conditioned by that door. That's a very easy starting point. Now, if passing through that door triggers certain jurisdiction, now you've got a lawyer involved in that common point that the heterogeneous elements are subjected to. This is obvious to the point of banal, but if you sort of play this out by analogy in other ways, you start to think of things that I would metaphorically speak of either as a translation device, something that allows communication from otherwise heterogeneous elements, whether that thing that allows communication is a door or a key or a satellite or a rule, a law, a norm. Or you can also think of it as a sort of transport, and I mean that from sort of computing, something that takes from one place and brings to another so as to bring two elements in conversation. And what would that transport be? That transport might be something used to register biological information about people, and that allows different modes of control, etc. That otherwise, so in other words, the law is implicated in these things and formalisms that can be found even in these challenging heterogeneous spaces with a lot of autonomous entities. And for the lawyer, thinking about the law in that way can be revealing about the work that it's doing.
Mm-hmm. Excellent, Geoff. Antonia, thank you very much. So in the next few minutes, Geoff, if it's okay, I want to show my students your article. Of course, I asked them to read it, but I just want to highlight some parts and ask you a couple of questions, or just one question. So this is the piece, well, one of the pieces. The other is Constitutions of Value. For those, of course, students were not required to read this. Perhaps the title for them is Professor Geoff talking about constitution. No, it's not that, and value is different, the problem of meanings. But let me begin with this. One of the reasons I invited Professor Gordon is to show the students what a good piece of research looks like. So from the formal point of view, I find that this is impeccable. In terms of course, I mentioned that the word method is very important, and how you employ the methodology in the context of your findings. There is one paragraph that I want to show my students that to me is a piece of art. Well, many, but in particular, a paragraph that I have here. Okay, so basically here you talk about critical realism, ontological realism, and epistemological relativism. And then you go on to explain what they mean. And in other paragraphs, well, in many other paragraphs, you try to balance views. So you present one view on the one hand, the other view on the other hand. There is something that Geoff achieves in all of his writings, which I find very difficult. I spoke about this with my students yesterday, which is the balance between being clear, but at the same time being dense. So it's not easy to be profound, deep, and dense, and to be clear at the same time. Of course, this is not a novel. This is a scientific piece, and one has to devote effort to read and understand everything. But well, when of course you have a BA in literature, you know how to write very well, but you also are able to convey ideas clearly, but you do not you are deep. So it's not easy. I gave my students an example yesterday, Geoff. When you go to the doctor, you want your doctor to tell you what you have. But you don't want your doctor to be too scientific that you don't understand anything, or that your doctor treats you like a person who knows nothing. You want to reach a balance. I am using this piece for purposes of essay writing. I would like my students, undergraduate students, to have this like an example of what a good piece is. And well, page 2096, I found this very nice, very well written. The tools you use to understand the deep contours of the law. Those are basically like my comments. I don't know if you want to say something else. I know that you have some self-criticism about your piece, but I think this is the examples I will use in my classes.
It's very hard for me to hear praise for my own work. It's I'm certainly, I suffer a lot of insecurity with my work. I appreciate in the work that I read the sophistication that comes from simple observations. And so telling it plainly is extremely important to me. And it gets quite dense quite quickly. I mean, I'm constantly confused by the world around me. And that may be why it's so important for me to constantly look closer. And there's a curious thing about writing that, for me, because I want people to tell it plainly, but because I also don't believe that there's a transcendent truth out there, I find it helpful when authors put a little of themselves in their work, so that they can tell it plainly with an understanding that there's a bit of the personal wrapped up in there. That helps me to understand where the author is coming from and what they're seeing. And then if you build in a stepwise progression from the plain towards a problem, from the simple to the complicated thing, you can get there stepwise, and it's easier for me to follow than something that's insisting on throwing the complicatedness at me all at once. Now, there's one caveat I'll put on that. When I read a good piece, I like to know where the argument is going from early on in the piece. When I read a detective novel, I like to not know where it's going until I get to the end. When I read a scientific work, I like a little bit of signposting at the beginning. Something that allows me to understand then, if the author goes back and does this simple stepwise progression, why this perspective is chosen, what is being built towards with a series of simple steps. So those are, I won't speak to my own work here, although I guess given the paragraph that you've focused on, it is worth saying to students, I think, that some of these thumbnail sentences require absolutely the most work. I mean, I look at that paragraph and I know that that was one of the paragraphs that I really agonized over, to be able to reduce each of those elements to a single sentence statement. Now, I knew I would have opportunity later in the piece to expand, but still to get it right in that paragraph. And I don't ever think I got it right, but to try took quite a lot of effort. So that's also worth stressing, that some of these exercises in clear, simple compression really are hard work. And so when I'm saying overall a simple stepwise progression, I do find that to be quite a challenge. and often more of a challenge than pouring out everything all at once.
Absolutely. Geoff, thank you very, very much. I will use this piece. You, as I said, I'm sorry about repeating this, one of the finest writers I've read. I cited you in one of the pieces I wrote last year. That's how I met you and knew you. And hopefully one day we can host you here in Bogota at Javeriana. We have a very nice team. Our dean is an excellent human being, is an expert on justice, theory of justice. Our head of the department is also a very very nice person, an expert on law and economics. We have like a tradition here at Javeriana of trying to link law and economics from different angles: international law, criminal law, civil law. So it was a privilege. I will use this piece for myself to learn, to write better, to conduct research in a better fashion. I want to thank Antonia, one of the best and brightest students, for your excellent questions. Thank Andres Felipe, thank my students. Next week, we will be discussing. I know that I didn't have too much time to discuss the substance, but in terms of methodology and of what we in Colombia have to do in terms of analyzing the law, of writing better pieces, we have a huge problem in the context of the law schools in terms of writing skills. We have to work much more. Students have to write much more. So it was a pleasure. Have a very nice evening. Perhaps we can have a few private minutes to say goodbye. Muchas gracias a toda la audiencia, Andrés Felipe, a todos y a la facultad. Muchísimas gracias.
Thank you from me as well. This has been an absolute privilege. Thanks to all the students who've been able to tune in. I don't know if we've already been dropped from the broadcast. Okay, we've not. So thank you all. Andres, we'll have a few more minutes, but I do want to say thanks once more. I hope that I can reciprocate. This has been absolutely wonderful. I look forward to carrying on the conversation. It's been a